Okay, we're in the chapter on civil liberties. We're going to be resuming here with slide number 8 in the PowerPoint. So we're talking about the different amendments that emerged, that became the Bill of Rights. And you can kind of read along. These are fairly self-explanatory, but the First Amendment deals with freedom of religion, freedom of conscience, freedom of speech, freedom of assembly, press, the ability to petition government for a list of grievances if you've got issues. And these are really powerful freedoms. Obviously the rest of the amendments are critical as well, but to me, the most important is the first. Not that the founders created a hierarchy. That's not what James Madison was doing when he created them, but so much of the rest of them flow from this core, that if you lose this core, you lose a lot, you lose a lot of the strength of the rest of them. Second Amendment, right to bear arms. Third Amendment, no quartering of troops in homes in time of peace. Hasn't happened yet since the founding. I hope it never will. Fourth Amendment, protection against unreasonable searches and seizures. Fifth Amendment, protection against self-incrimination and double jeopardy. I plead the fifth. There's actually another section of the Fifth Amendment that's not listed there that is something called eminent domain, and it gives the government the ability to take your personal property for some sort of public use as long as they pay the fair market value of it. Sixth Amendment, go to the next slide, right to a jury trial, right to an attorney, right to confront witnesses. Again, these are dealing with federal trials, okay, as we'll talk about shortly here. At least initially, it was interpreted by the Supreme Court that these amendments applied specifically to the federal government, not to the state governments. Seventh Amendment, suits in common law over $20, which given money today, that's all of them. Jury trial preserved, no fact tried by a jury shall be re-examined in any court of the United States. That's this principle called double jeopardy. Eighth Amendment, protection against cruel and unusual punishment. Ninth Amendment, certain rights shall not be construed to deny or disparage others retained by the people. What does that mean? James Madison created this because after reviewing the first 8 amendments that he created, actually he created 2 other ones, but I'm not going to get into that right now. But when he looked at least what he had created, he realized that, there are certain other rights that I haven't listed. So kind of he created this what I call the Ninth Amendment, almost like a blanket amendment that basically says, the other rights that I didn't mention, the people still have those as well. I'm not going to list them all. In other words, it wasn't intended to be exhausted, but given the fact that I've already listed, freedom of speech, freedom to petition government, freedom of religion, right to bear arms, in other words, all these rights, there are other rights that we haven't listed, and the people enjoy those rights as well. And then, of course, the 10th Amendment, which is a really important one. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the people. Okay, and as the framers of the Constitution understood it, this meant that most of the rights and most of the power was at the state level and with the people. James Madison said this in a Federalist paper, I believe it's Federalist 46. He said, basically, the powers of the federal government are few and defined, but the powers of the state governments are numerous and indefinite. Okay, and that's what the 10th Amendment captures. Okay, now it's been incredibly neutered in the present era by a lot of Supreme Court decisions, okay? But as it was set up originally, most of the power lay with the states and the people. The federal government had lots of power, but it was limited and it was very, very well defined, okay? So if you go to slide number 10, you can see a case here called Barron versus Baltimore. And it was the first case before the Supreme Court, this is in 1833, where the question was asked, do the first 10 Bill of Rights, do those apply to the states and the state governments? Does it limit what state governments can do, or is it only applied to the federal government, okay? Think of the First Amendment. It says, Congress shall make no law prohibiting, religion, okay? Congress may not, but states could. And if I haven't stated this already, I will right now. It wasn't until the 1830s when state churches were eliminated within the individual states. In other words, the federal Constitution did not prohibit individual states from having their own established religion or their own established church. Okay, and so, because again, the thinking was, these apply to the federal government. The states are free to to choose whatever they want to. Remember the 10th Amendment. The right's not expressly granted to the federal government; it's reserved to the states, and so they gave them that power. So anyway, an issue before Barron versus Baltimore is this idea that do the Bill of Rights apply to the states? And so the ruling said this: basically, the first 10 amendments contain no expression indicating intention to apply them to the state governments. Okay, so in other words, the Bill of Rights had very little meaning in the daily lives of your average citizen, because state governments had authority over most of the activities where individual rights were an issue. In other words, if you wanted to get your rights, you had to go through the state governments, the state legislature, to get, to establish rights. The federal government was kind of, we're not going to deal with that. The federal government and the Supreme Court is not going to reach its hands into the cookie jar, if you will, of what the state governments are doing. Okay, so that was settled law in 1833. However, it didn't stay that way. And what you'll find out with the history of the Supreme Court is they tend to what they call arrogate power to themselves. Okay, in other words, they tend to grab a lot of power to themselves in their Supreme Court rulings. Okay, something that was actually quite remarkable, because when the founders created the Supreme Court, they really felt that was going to be the weakest branch of the government. And if you remember Federalist 51, where James Madison said, listen, the great difficulty of establishing a government of men over men is this: you must first establish the government to control the governed, and then in the next place, oblige it to control itself. In other words, you've got to find some way to oblige the government to be self-controlled. And the history of the Supreme Court, even as I'm recording this in the third week in June, the court does not exercise a lot of self-control. And that's one of the problems with governments that have people, right? As the founders thought and said, government is people, and people are flawed. And you've got to find some way to rein in the federal government. So what happened after Barron versus Baltimore, and this is in particular what occurred after the passage of the 14th Amendment, is the court engaged in something called selective incorporation. And that's the process by which certain of the rights contained in the Bill of Rights become applicable through the 14th Amendment to state government. So in other words, the 14th Amendment is really important because it becomes like this portal, okay, that the Supreme Court can reach through and justify limiting the power of state governments, okay? And so let's read the 14th Amendment. It's in slide number 12, okay? It says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Again, the 14th Amendment was created to give the newly emancipated slaves rights of citizenship. So here's the operative phrase in the 14th Amendment that becomes this portal by which the Supreme Court reaches through and starts limiting state governments. It says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, okay? Whereas, again, take the First Amendment, Congress shall make no law prohibiting, okay? Deals with the federal government. In the 14th Amendment, it now says no state shall. So basically it starts limiting the power of state governments. The only problem with this is the 14th Amendment was created specifically to give the newly emancipated slaves equal protection rights, rights of privileges and immunities, and the right to due process. It was not created beyond that. In other words, it only applied to the newly emancipated slaves. It did not apply to this group or that group or this group or that group seeking new rights, trying to go through the 14th Amendment to get it, okay? It was originally written to be interpreted very narrowly, okay? But what the court started to do is they started interpreting the 14th Amendment broadly and started saying, listen, that doesn't just apply to the freed slaves, it applied to all these other groups, okay? One of which was corporations. And they gave them rights, okay? So again, this is where selective incorporation began, okay? And so if you go to slide number 13, you can see this. They attempted to apply it to First Amendment rights rights dealing with where states maybe limited some form of free speech. Now the Supreme Court, through the 14th Amendment, through that portal, if you will, started basically limiting state governments where in the opinion of the court, states were limiting free speech. Okay, in Neer versus Minnesota, there was a case dealing with how the states perhaps limited the power of the press. In the case of Hamilton versus Regents University of California, this dealt with how the court felt that the states were limiting the expression of religion. And then in DeJong versus Oregon, Assembly and Petition. Again, you don't have to remember these specific cases. If this were a constitutional law class, you would. But what you just need to realize is again, that 14th Amendment suddenly became this, oh, I think I can use this to say this, okay? Going far beyond the original limited parameters of simply rights for freed, emancipated slaves. Other examples, if you go to slide number 14, selective incorporation of fair trial rights. In Matt versus Ohio, evidence required through an unconstitutional search cannot be used to obtain a conviction in state courts. Gideon versus Wainwright, defendants in state criminal proceedings must be provided a lawyer in felony cases in a state, okay, if they can't afford one. Malloy versus Hogan, those that have been accused of a crime cannot be compelled to testify against themselves. This dealt with police coercion. Think of dark room, bright lights, lots of smoke, and trying to coerce them. You can't do that. And then in Miranda versus Arizona and Escobedo versus Illinois, this is a familiar one, this idea that you have the right to remain silent and anything you say will be used against you in a court of law, okay? Why that's significant, besides the fact that that's really familiar if you've ever watched a crime show, is that, again, that applied to state governments as well as the federal government. Again, selective incorporation, okay? Others examples of this, if you go to slide number 15, there's selective incorporation of fair trial rights. In Pointer versus Texas in 1965, those that are accused have the right to confront witnesses who testify against them in state trials. Again, in federal trials, they already had it. This was new. In state trials, Klopfer versus North Carolina must be granted a speedy trial. According to the Supreme Court, what's a speedy trial? In other words, you get, accused of something, you get thrown into jail. In other words, the amount of time from being thrown into jail to basically having your day in court. What is a speedy trial? According to the Supreme Court, it is, wait for it, 100 days. So over 3 months, you have to wait in jail perhaps. But a speedy trial is you must be tried within 100 days. Kind of interesting. Benton versus Maryland, 1969, you cannot be subjected to double jeopardy. In other words, you can't be tried by the same crime twice at the state level. Again, that was always there at the federal level, okay? So let's begin here talking about freedom of religion. Okay, slide number 16 rather. It said, the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So what does that mean? That means Congress can't establish a state church, okay? Or some politically correct religion for everybody. But it cannot also prohibit the free exercise, in other words, the expression of religion. So Congress can't establish a state church or some form of orthodox religion, but it can't prohibit the expression of religion by individuals, not just privately in your home, and not just privately in a church or a synagogue or a mosque, but publicly. In other words, freedom of religion is the freedom for individuals to freely speak and persuade others that their deeply held religious beliefs are true, okay? In other words, it's not just a private thing like freedom of worship. In other words, you go to a communist country, you go to North Korea, there's freedom of worship. In other words, you can freely worship whatever you want, whatever God you want, as long as it stays between your ears and your mouth is shut. Freedom of religion is much more broader. It's much broader than that. That's not just the right to freely practice a religion privately in your own home, but also publicly. You can talk to other people about it. That's freedom of religion. Okay, so that's why it's really, really significant. If you go to slide number 17, religious liberty or soul freedom is simply the right of individuals to have freedom of thought, freedom of conscience, okay? In other words, the idea of religious liberty is a right for everyone, okay? Regardless of whether it's respected by a state or not, okay? Where it's more confining if it's civil liberty, okay? Civil liberty is the liberty that you enjoy because you're a citizen of a nation, okay? Do you see the difference? Religious liberty, the idea is it's more broader than any state. Whether a state recognizes it or not, because you're human and you're currently alive, you enjoy religious liberty. But civil liberty are the rights conferred to you by a nation, okay? In other words, the rights conferred by the American government to American citizens is very different than the rights conferred to citizens or were recognized by the state in North Korea, okay? And, you know, so the more fundamental right is religious liberty, okay? And so freedom of religion, why it's important, okay? It comes first. Actually, you know what I'm going to do? I'm going to stop here, and I'm going to just do a quick video on slide number 18 next.